Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, practicing out of British Columbia. As always, Samfiru Tumarkin is Canada's leading employee-side employment law firm. Okay, housekeeping notes. If you want me to answer your questions, please send them in the next 30 minutes. As always, if you need to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Please send in all your questions as soon as you can. I'd like to get through all of them. They tend to come in sort of in bunches at the end, and I want to make sure I answer everyone's questions if I can. Thanks. Okay, let's see here. What do we have? Question from Caroline. My employer claimed frustration of contract while I was on a leave of absence. Do they not owe me severance pay because of this? That's a very interesting question. Okay, so just for everyone's benefit, when you are terminated without cause, your only legal right is severance if your termination date is today, okay? Your employer can't terminate you while you're on a leave of absence without incurring human rights penalty in the form of human rights damages and also severance of some kind. The amount varies based on your contract, if you bring your matter entirely in a human rights regime and based on jurisdiction, but certainly human rights damages and severance. However, that changes if the contract of employment between the parties is it's called frustrated, or in this case probably medically frustrated if it was a medical leave of absence. And what frustration is, it's a legal doctrine where through no fault of either party, the employee is not able to complete her obligations under the contract of employment, and therefore the contract of employment is effectively extinguished, including the severance obligations of the employer to the employee. So I'll give you an example. Someone's works for a company for 15 years, then they get a terrible medical diagnosis. They're unable to work for a year and a half. The test in BC is about a year and a half. It's similar in other jurisdictions as well, more or less, but unable to work for a year and a half. And there's no prospect of the employee returning, of medically being able to recover. So you have to have those two things: a prolonged absence and no possibility of return in a reasonable amount of time after that longer period of time has passed. And so if both of those things occurred, then yes, your employment can be considered medically frustrated. Now, you can certainly get edge cases. I had one, but it was about a year or so. Employee was off for a medical leave, trying to return to work, and the employer didn't check with the employee to see what her medical prognosis was going to be, just fired her. I think in that situation, certainly there was scope to claim that in fact there was no medical frustration and that she was entitled to severance. So in your situation, you need to talk to an employment lawyer right away. You need to find out, how long have you been away for? If you've been out for 5 years, it's much more likely that this is frustration. But there needs to be, in most jurisdictions, there needs to be some attempt by the employer to verify that you're not coming back, right? There's no medical possibility of you coming back. So if you have a medical opinion from your doctor or specialist that says your back injury or whatever it is permanent and you're never going to be able to work again, that's the end of the discussion. Your contract, your employment has been frustrated. They don't owe you anything. But if you are working to come back and you just don't have that approval yet, but you may have it, you can get certain medical notes that completely, or a medical note that says, I expect to reassess in 4 months, and the goal is to have her return to work on a gradual basis. I think that their frustration defense becomes very, very difficult. So, Caroline, you should talk to an employment lawyer right away. If you need to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Just a note about medical frustration cases. They can be very complicated because they have to do with what are the nature of the injuries? What is the prognosis for those injuries? And then based on that prognosis, can the employee do the core functions, or will the employee be able to do the core functions of her job in the future, right? So if you have a back injury, you have a back injury, 2 of the vertebrae in your spine were fused, and you used to be able to lift 65 pounds. Now you can only lift 20 pounds, and your job requires you to lift 40 pounds on a daily basis. Arguably, even though you can still work, you're medically frustrated from that job. And that's where you get into the nuance of complicated medical analysis in terms of how much, does your injury preclude you from working in that job forever? So it's not just, do you have a medical injury? Does that medical injury, a medical injury that's not going to get better, does it prevent you from doing the core functions of the job? So you have questions about injury, prognosis, and core function of the job. So they're incredibly complicated. You can't go it alone. You need a lawyer. Nonetheless, if they're wrong, Caroline, then certainly you might have a substantial severance. I mean, I don't know, how long you've worked there for, what your employment contract says, but it's entirely possible you have a substantial severance claim coming to you. Or that you have a substantial severance claim, I should say. So contact an employment lawyer as soon as possible. Bear with me one second. I'm just going to close a window here. There we go. Sorry if anyone was disturbed by that background noise. Okay. Let's move on. Joanne asks, my employer wants me to go for a medical assessment before I return to work from being on LTD. Can they deny my return or let me go if they don't like the result? So this is a similar question to the last one, although not quite. So just to give you a little background, everybody, Joanne has had some sort of injury outside of the workplace that has prevented her from working for an extended period of time. So she, through her insurance benefit coverage, through her employer, most likely, has been on long-term disability. Now, it's not clear if Joanne has received some sort of medical clearance to return to work on a gradual basis, but the employer is saying, we want to have you attend our own assessment to see if you can return to work. And so it's not clear from Joanne's question if she wants to stay on disability, but they're trying to assess whether or not she can come back anyway, or if her doctors have cleared her to return to work, and they're saying, well, they don't want her to come back to work, so they're going to send her to their own doctor that says, no, she can't work. So, Joanne, I can't fully answer your question. My opinion has been, in matters like this, if you have a doctor's note that says, yeah, Joanne can return to work on a graduated basis, you're entitled to rely on that you have no obligation to go to their assessment, which is clearly just designed to say that you can't work. Okay. So, and if you provide them your medical note from your doctor who's cleared you to return to work on whatever basis, and they deny you return to work, I'd call that a termination of your employment and pursue it that way. However, and this is a big caveat, I have not looked at the law on if you refuse to comply with a request for a medical assessment from an employer because you have your own medical approval to return to work. I don't know what the result of that is. If you're in BC, Joanne, I'm happy to look that up for you because it's actually, I'm quite interested in it. And actually, I don't know if you're in BC. If you are, if the moderator could put my contact on the screen, certainly please reach out to me. If not, please, there you go. You can see my contact in the top left corner. If not, feel free to contact us, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. So just to recap, Joanne, my take on this is no, they can't. Your doctor's note is sufficient. However, I'm open to being incorrect about this, and I think that you need to have a lawyer look into it and find out, is the employer entitled to get its own opinion about whether or not you can return to work. And if it is, maybe that has to do with questions of safety, where they want to make sure that, before you go back into the mines or something that has substantial safety concerns for not just you, but other people, that you can in fact do the job. It's probably an individual case by case thing if it is in fact a requirement that you allow yourself to be medically assessed by their doctors. But be under no illusion here. The reason why they want you to go to their doctor is because they want an opinion that is different than the one that you want. Generally, that's why that happens. And so, if your doctor is cleared you to return to work, and that's what you're trying to do, and I don't have enough information from you, Joan, if you can maybe follow up, that would assist here in this chat forum. But I think you're entitled to rely on my doctor says I can go back to work. Here's my medical note. Schedule me, please. And if they say no, you could treat that as a termination. But whether or not you'd want to depends on, do you really want to go back to that job? What your employment contract says. If your employment contract limits you to 8 weeks of severance, you're not going to. You probably just want to comply with what they do, with their request. What kind of severance claim you have coming to you, what the open job market will pay you. There's a whole bunch of factors, but certainly you're going to need to talk to an employment lawyer about that question, because that is one I can't answer off the cuff, other than my general impression is you're entitled to rely on the medical opinion of your doctor. Okay. Jess asks, I was put on temporary layoff after 21 years of employment due to shortage of work. I have to wait 13 weeks before I'm potentially offered 8 weeks of termination pay. It's a very specialized position, and I don't know if I can find another. It also seems that only people of color were laid off. Is this discrimination? Okay. Let's tackle the second one first. So if there's a layoff of 10 people and 8 of them were people of color, and the workforce there is primarily not people of color, I think you probably have a discrimination claim, and I think you probably have a significant one. But you'd have to have specific numbers, right? Like if it's 4 people were laid off, 5 people were laid off, and 2 were people of color, I don't think that's going to get you there. But if you have a substantial enough threshold, and you can prove that, then I think the bar for for actually making a human rights complaint is plausible claim, and certainly that would get you there. And I think that the Human Rights Tribunal is very good at, because no one outright says I'm discriminating against you on the basis of X. The Human Rights Tribunal has to look at the evidence and read between the lines to an extent, and they're very good at that. And so, if it is a situation where obviously a disproportionate number of employees selected for layoff were people of color, then you might certainly have something there for a human rights complaint. And not only might you have it, you might want to, you certainly might want to bring that before the Human Rights Tribunal. So that's what I'll say about that. And you should talk to a lawyer about that, and I'll give you the details at the end. Okay, the first one. So sounds like you're provincially regulated. You're a 21-year employee. You're laid off due to shortage of work. Okay. Now, what a layoff is where an employer can temporarily suspend you from working, so specifically stop paying you because it has cash flow issues and can't afford to do so. And the idea is, behind the way the layoff regime is structured in the Employment Standards Act, is to give employers the flexibility to be able to do that and then call these employees back to work. So if this is just a temporary blip here, Jess, and then you're going back to work, then great. You got 21 years of service. You want to probably keep working there. There are lots of people that have, that get laid off a couple times a year. That's just the nature of their industry and that business, their employer. But they always come back to work. But it sort of sounds like you think this is a permanent thing. So if this is really just a layoff that's about to be a termination, you have two options. Yes, you can wait 13 weeks, and then you're terminated by operation of law, by operation of the Employment Standards Act, after 13 weeks after the layoff. Or you can claim constructive dismissal, that you did not agree, if in fact you did not agree for your pay to be suspended. There's no right in law for the employer to do that unless it's in your employment contract that says they can do that. But you didn't agree to it, therefore you've been constructively dismissed, and you can claim it that way. Now, the danger if you do that is if the employer says, we're recalling you to work, you got to go back to work. Even though you made this allegation, you have to go back to work, and if you don't, you quit and you get nothing. Okay, so that's the risk. You can wait for 13 weeks until your termination is triggered, but you probably will get another job in the interim of those 13 weeks. And in terms of severance, your entitlement to severance, you're not entitled to double compensation. So if you're laid off here, you get a new job after a month, any money you make from the new job is deducted from your severance claim. So if the new job pays you the same, your severance claim is worth zero. Okay, so that's the danger of having to wait 13 weeks. The 8 weeks is your automatic guarantee after termination that you get under the Employment Standards Act. However, if you don't have an employment contract that limits you from common law severance to Employment Standards Act minimums, and just to tell you the difference, Employment Standards Act severance, the 8 weeks, you're maxed out at 8 weeks. It's a small amount. Common law severance is much closer to 1 month per year of service to a maximum of 24 months. So you might have a best day of 21 months here, Jess, in terms of severance, which is a substantial amount of money. So you're absolutely 100% going to want to talk to a lawyer about this one. What determines which one you get, the small severance or the big severance, is your employment contract. So you're going to have to get a lawyer to analyze it if you have one. If you don't have one, you automatically get the big severance. But here's the complicating factor, at least in BC, okay? And that is, it's not clear that if you're terminated by operation of the Employment Standards Act after 13 weeks, as you said, you get your entitlement to Employment Standards Act notice, which is 8 weeks, but it's not clear that you get an entitlement to common law severance, the big severance, from that termination. The termination may be for Employment Standards Act severance only. I know that doesn't make any sense. I don't think it makes sense, but there's emerging law around this concept that if you want common law severance, there has to be something that in the reasonable expectations of the parties severs the relationship as far as the employment relationship, as far as common law severance is concerned. So, a demand letter from your lawyer saying, we want common law severance will probably do it, or I consider this a termination, or claiming constructive dismissal. So you have to be alive to that sort of, at least in BC. I mean, I don't know about how other provinces have treated this and if they have the automatic termination or not. At the end of say 13 weeks or whatever the period of layoff is under the Employment Standards Act. But you have to be alive to this notion that you want the big severance if it's possible, and you need to make sure that your termination is triggered for the big severance at law. Okay, and that's it's really inherently complicated. You're going to, and it's a new emerging area of the law that came out of jurisprudence during the pandemic. So you really need to talk to an employment lawyer, Jess. You need to do it right away. If you want to talk to us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. And Jess, I've actually done a lot of work on that particular issue, that last one. So again, if you're in BC, please feel free to reach out to me. But otherwise, I recommend that you contact an employment lawyer right away. Okay. I can't say this person's name without identifying them, so I'm just going to call them R. R says, working in sales, an employer wants to decrease our commission amounts. How much are they allowed to decrease those by? It's the age-old battle between employers and salespeople, where the employers say that, you know what, we're paying our salespeople too much in commission. let's reduce their commission payout. Happens all the time. I talk to 20 people a year where this happens. It's unfortunate that when it happens to you, it's an unfortunate thing to have your compensation decreased. The short answer to that is, if your overall pay is, I'll just talk about BC, but this is more or less true across the provinces. If your overall pay is reduced, your take home is reduced by pre-tax take home by 20%, you've been constructively dismissed. If you elect to consider it a constructive dismissal, and then you can proceed to go after severance. Now, why would you do that? If you don't have an employment contract with an enforceable termination clause, and you have a reduction in your pay by 20%, you claim constructive dismissal, and you may have a very lucrative severance package coming to you. So that's why you would do it. If it's below 10%, it's not going to be a constructive dismissal. If it's between 10 and 20, then it can be a constructive dismissal, particularly if something else happens as well. That where the employer indicates it doesn't want to be your employer, or there's a demotion involved, but it's the reduction plus something else. Okay, in between 10 and 20, generally speaking. So that's how you calculate that. If it's a reduction in your commission by 6%, it's not going to be a constructive dismissal. However, if it's a reduction of your pay by 6%, and then 8 months later there's another 6, and 8 months after that there's another, it's 7. At some point, it's a death by 1,000 cuts, and I think you can claim constructive dismissal tying all those cuts together, because over a 2-year span they reduced your pay by 30% or something like that. So obviously these are very complicated. You're gonna, if any of what I've said corresponds with your situation, talk to an employment lawyer right away. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, I'm going to try to get through these as quickly as possible. We had some technical difficulties at the beginning, so we were slightly delayed in starting. So I'm just going to go quickly through these. Art asks, my employer is telling me I have to change shifts. I'm on a shift I requested 6 years ago so I can take care of my children. Can they force this change? Well, depends depends what your childcare responsibilities are. If your kids are now 6, you have a good case, but if your kids are, they were 6 and now they were 8 and now they're 14 or something, it might be a little bit harder. But your kids might have specific healthcare needs that you need to attend to. So it also depends on the nature of the shift change. If the change was from 8 to 5 to 10 to 6 or 10 to 7, maybe not, right? But it depends. But yes, at least in BC, you have family status protection, and how I've handled these in the past has been to say to the employer, listen, I advised you 6 years ago, I have these specific childcare obligations. I can't work this shift. I remind you of that, and I request that I stay on my existing shift. And then if that does not work, you certainly do have some legal recourse, and depending on your jurisdiction, I don't know at all if family status prohibited human rights protected ground is included in other provincial jurisdictions or the federal jurisdiction, but it certainly is in British Columbia, and this would be exactly what it could assist with. So I sound like a broken record today, but Art, that's a very complicated matter. You're definitely 100% going to need to talk to an employment lawyer about that. I'll give you all the contact details at the end, but for us anyway. But yes, you have to talk to a lawyer about that. But the short answer is there are some strategies to try to keep your shift that you could engage in, and then there are legal recourses you might have depending on the jurisdiction you're in, what province you're in. Okay, Sam asks. Oh, Sam is just complimenting us and saying it's a great session, and thank you for all this information. Appreciate the kind words, Sam. You're very welcome. Jay asks, Are there any red flags to look for in regard to disability medical insurance when seeking a provider? I am not an expert on disability law at all. We have disability lawyers here who do Q&A sessions. If there's one coming up, maybe the moderator can post that on the screen for the next disability Q&A session. But certainly join us for the next one, Jay, and you can ask that question there, and you'll probably get a good answer. Okay. Andrew asks, I have a workers' compensation case. I'm going to therapy. How long does settlement take in California? Okay, so one, Andrew, I don't work on workers' compensation matters. Nobody at my firm does. It's very specialized here in British Columbia. Very few lawyers do, and we don't practice in California, nor are we familiar with. Oh, there it is for Jay. Join us on September 12th with Alex for an employment and disability law Q&A. There you go. So join us then, please, Jay. But Andrew, we simply don't practice in California. We're not called to the bar there, and we're not familiar with its legal structure, so we can't answer that question. And I'll direct you to a workers' compensation lawyer in California. Sam asks, what was the shortened form of it that started with employment law? I don't know what you're referring to, Sam. Please clarify. I can't identify this person. The nursing home where I work is closing. They built another nursing home in a different town. Dilemma is can't work in a different town and I don't drive and no transportation. And am I eligible for severance? Yes. If it's not possible for you to get to that new location, then they are in effect, unless they provide transportation for you, I would imagine. Or hold on, is it within reasonable transportation distance? So is there a bus that goes there? If there is, then I think you're out of luck. But if there's no possibility of you getting there, then I think you have a severance claim that they're in fact terminating you. That's a tough one. So I would recommend that you speak to us as well. I'll give you the contact details at the end, or at least to an employment lawyer. Okay, we're almost done. Sam asks, any regulatory agencies for understanding who or what can be a decision maker, especially if the parties are identified and are neutral parties? Sam, I don't understand that question. Yeah, sorry, Sam. I don't know what you're asking specifically. Last person jumped in again. There is no public transportation between those two locations. I mean, they're going to continue your employment. They probably said that. I would say you're constructively dismissed by that. But constructive dismissals are always challenging. That's where they're harder. It's where the employer hasn't overtly terminated your employment, but through its actions has in effect terminated your employment and shutting down your location and moving to a place that you can't get to is a constructive dismissal of your employment. But you've got to take action relatively quickly after that, claim constructive dismissal, and move forward with your severance claim if there is value to doing so. So I'll call you H. You need to speak to an employment lawyer very quickly. So I'll put our contact information on the screen. Please contact us if you'd like to speak to us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Jay asks about doctors having competing opinions. Sorry, Jay, I don't know what you're referring to here. Oh, this is about the medical disability. Yeah, no, you'll have to tune in for our disability broadcast on September 12th. For now, please join us on September 9th at 1:30 p.m. with Chris Justice. He will be answering all questions, employment law then it'll be a good session. Please join us then. Otherwise, you'll see me in 2 weeks at my regular time slot, 10:30 a.m. Pacific time in 2 weeks. Please join us then. Great question, really great questions today. Thank you all. Appreciate it. Have a safe and wonderful long weekend. Or not long weekend, weekend.